No, I don't want another bite.
Okay.
I thought you were implying I needed to bite some.
No, I was inclined not to give you one because I was, no.
We're done biting, Your Honor.
We're done biting.
Okay, no worries. The apple seems to have enough. Okay. Counsel for plaintiff, are you going to refer to the Russians?
Well, Judge, there's no way Mr. Marlowe can testify without talking about the Russians.
I think there's a statement that I'm staying tuned for Monday to hear a little bit more of an explanation on.
We're laughing because we don't
No one's
disagree.
disagreeing, Your Honor.
Counsel, I didn't want to take over the thunder, but
Yesterday he stole my thunder. Today he's the court. That's fine, Your Honor.
I'm not taking
That's
anybody's
okay.
thunder. Come on, I let you go in front of the camera,
You did. You
yesterday
did.
multiple times.
No, I appreciate that.
Counsel, Mr. Parker, did I miss one?
Your Honor,
I did. I'm sorry. I missed Blaine
671,
Jones.
but I think you ruled on it in
I missed
terms of
Blaine
what you
Jones.
said yesterday. But just in case the court wants to make a formal pronouncement on that motion.
Yeah, sure. You're 100% correct. As soon as I said that, I was seeing Blaine Jones, and I was
Yeah,
like, okay.
I don't think that we ruled on it to the full extent yesterday. Yesterday it was on the issue.
So let me call it then, and let's you all be able to express that in a oral argument standpoint. So, court is actually on document 671, Terrible Herbst, motion eliminating number 14 to exclude evidence, reference, and testimony related to alleged injuries sustained by Blaine Jones. The court's inclination therein is most of this has already been ruled on by the court with regards to what would be allowed to come in, what is not pre-admitted, to the extent there is a broader reference in this one that actually goes to any kind of evidence and reference. The court does see that that needs to be addressed so we have a clarity to make sure you don't have an inconsistency of ruling. Because remember, Blaine Jones is already a managing speaking agent pursuant to a court ruling. The mere fact that he's a plaintiff is allowed in for the limited purpose that the court already addressed. If it comes, right, subject to what comes up in testimony and subject to any agreement between the parties on how to work that. With regards to certain specific documents, they're not pre-admitted. So whatever you think is left, counsel for movement, on behalf of Terrible Herbst, on motion eliminating number 14, go ahead, please.
Thank you, Judge Tomasik, for Terrible Herbst. Your Honor, we moved to exclude testimony by Blaine Jones regarding his alleged injuries, which he claims are related to real water. To put the request into context, if you look at page 5 of our motion, we have videotaped testimony here that was played during the opening statement during the Gallagher trial. Now, this is exactly why we moved to preclude such references. If you look at what was introduced in the first hours of the trial, for example, on line 15, the pain, confusion, and fear I had learned about acute liver failure and hepatitis over the last few weeks invokes the old phrase, I wouldn't wish it upon my worst enemy. Now, obviously, that's prejudicial language to be played in front of the jury, and immediately the jury will be...
Counsel, you understand, I'm going to do a quick caveat here, right? Whatever rulings Judge Williams made in the Gallagher case, or whatever rulings Judge Williams made in the Gallagher case, please do not ask this department, its next door neighbor, to somehow say that he made any rulings which are incorrect,
Nope.
correct, prejudicial, probative, etc. This is the Hunwardsen case. And I understand that that's probably not what you meant, but
Exactly.
you could understand if someone neutral third party were listening to that. That's
I'm
what
not.
it sounds like. So
No,
let's just
no.
make sure we're...
I'm just trying to, give the court some context of where we're going with this, right? So, for example, you can see how that would be prejudicial. If you go down to line 20, and in the morning you had thought what you thought was, quote, food poisoning, unquote. Yes. So right there we have some inclinations that, Blaine Jones's testimony is being provided for causation when he's a lay witness, in this matter. And for him to be able to testify as to his opinions, what caused his alleged injuries, will confuse the jury. If you go down further to line 25, next the doctor told me. So we have now hearsay that's being introduced as well. If you go to the next page, Judge, line 1, I believe that was what the doctor said. Yes, if I remember correctly. So now you have hearsay, and Jones can't even remember correctly what the doctor was telling him. Okay. Now, here's why I wanted to put this out there and kind of lay some foundation for this. The jury will be misled if testimony like this is admitted, and especially so if it's set forth in opening statements. Now, I know there's some argument that this type of testimony, because he may be the managing speaking agent, may be admissible, but this sort of testimony is causation opinion testimony by a lay witness, and so for those purposes, he takes off that 30B6 or speaking agent hat and puts on his personal testimony, which here, it's hearsay, and he can't even remember correctly what the doctor told him. So, going forward, further, Judge, this testimony should be excluded because simply it's irrelevant to the claims and defenses as it relates to retail product. During that deposition, Blaine Jones explains that all of the injuries he believes, and he's not qualified to give those opinions, but he says that all of those symptoms he felt are a result of HOD product, right? And it's all after August of 2020. So therefore it's irrelevant and extremely prejudicial. Now, we believe that this request also is supported by Nevada case law. Hansen stands for the same proposition, where interjecting collateral issues is going to mislead the jury. Such testimony should be excluded.
Okay. Are you saying Hansen supports your proposition
Yes, Judge.
on exclusion?
Yes.
Okay, thank you so much. Counsel, wait, hold on a second. Let me make I have Real Water has a joinder, non-substantive joinder. Real Water.
Nothing to add, Your Honor.
Counselor Clintus, would you like to respond?
Yes, Your Honor. First, do you have any questions? Because I think the court has already given its not more than an inclination by the decisions reached yesterday.
Is Blaine Jones coming in by deposition or live testimony? Do you all anticipate?
We believe we did deposition testimony, but I believe he's local, Your Honor, so there's a chance he may be here in person.
The reason why the court's asking the question is, realistically, if you all are having an opportunity to, if he's coming in by deposition and you're having an opportunity to do line by line objections, then wouldn't it be better to address this line by line than in a more global context? If you think he's coming in person, might be different. Do you want Mr. Kemp? Who's handling this? Mr. Kemp or Mr. Parker?
Well, you can answer in terms of him showing up. I had another point.
I think we're going to play the deposition because I don't want to use Mr. Odou's dynamite analogy, but firecracker at least. There's potential of things that could go wrong having Mr. Jones live, so we don't really want to call him.
You know your witness better. I mean, as you know from this court standpoint, you could easily do a stipulation, you know what I mean, where to the jury the court is only allowing X or something, you know what I mean, or you can say agreed upon facts. You can put, there's so many different ways you can handle that. I'm not telling you all however you want to do it. My question is just simply depo or live, because if it's depo, I will tell you this court is more inclined to give you all the opportunity to, since you're going to be doing actual designations, do this in a concrete fashion rather than a hypothetical fashion.
Yeah, and we're filing our designations for Mr. Jones today.
Counsel, I didn't want to take over the thunder, but
Yesterday he stole my thunder. Today's the court. That's fine, Your Honor.
I'm not taking anybody's thunder. Come on, I let you go in front of the camera, yesterday multiple times.
No, I appreciate that.
Okay, so go ahead with your argument. But it's a
I
practical
got nothing else
question.
to say. You're taking it all. No, Your Honor. I got just a couple of things.
Sure, go ahead, please.
So, quite often I find attorneys use this defense that some particular piece of evidence is going to be prejudicial, not understanding that it's the standard is unfairly prejudicial, Your Honor. Every piece of evidence is going to be made prejudice or harm one side or the other. That's why the evidence is being produced. And so I don't like this conclusory remarks that it's prejudicial, and as a result, it shouldn't be allowed in. It's inadmissible. And that's just not the case. The other thing, Your Honor, and I understand why the defense has done this, but when you made mention that Mr. Jones, Blaine Jones, has been determined to be a managing speaking agent, under Rule 32, it comes in for any purpose. And that's the plain reading of the rule. And so they're trying to find a carve-out without any, in my opinion, any case law supporting this carve-out from the rule. The other thing I would suggest, Your Honor, some of the points that defense counsel would like to make in terms of Mr. Jones, that goes to weight, not admissibility. So I don't believe the motion should be granted. I do agree that if we want to fine-tune the process as a part of the deposition designation exchange that we'll do, that's fine, Your Honor. But one other thing I want to point out is Mr. Odou said, and I tried to write it down as best I could verbatim, that Mr. Jones, this is in response to Blaine Jones versus Ms. Converse, if you can harken back to what Mr. Odou said. And he said this in terms of Ms. Converse being the QA person, not having access to the secret concentrate room. Mr. Odou said that Mr. Jones was the executive vice president. He made all the concentrate. He had access to the secret concentrate room. He was an officer of Real Water, and as a result, he was in a superior position than Ms. Converse was for quality control or quality assurance. And I'm quality control, but I knew it was one or the other, Your Honor. He is the voice of Real Water, and he was the voice of Real Water during the Southern Nevada Health District investigation, Your Honor. These comments are statements against interest. His comments as a speaking managing agent and that deposition that came from it can be used for any purpose, Your Honor, and I think the motion should be denied.
Okay. Counsel, you're the movement. Does it make more sense if he's coming in via deposition to give you all the opportunity to see what actually is being designated, what is or is not being counter-designated, what is or is not being objected to line by line, rather than having the court rule a conceptual ruling today that may be different when you actually show me what the testimony is?
Well, I think
yes, I phrased my question in a particular way. Go ahead.
I think there is one thing that we should rule on today, and that's the fact that Blaine Jones his testimony is being proffered for causation, and he's a lay witness. I mean, the case law is clear on that in Nevada, a layperson cannot testify as the causation for an injury. So his opinions, any testimony he makes about the cause of his injury should be excluded.
Okay. He's not a plaintiff in this case.
I understand that.
Okay, right? You all agree on that. So how is it saying it's causation versus plaintiff's contention more is the circumstantial evidence, if it's asserted certain things that they need circumstantial evidence to say that it was actually the Real Water that caused Hunwardsen, right? Because you're only caring about Hunwardsen. So,
well,
isn't there a
it's not that we
there?
only care about Hunwardsen. If the jury is going to hear Blaine Jones set forth causation testimony, and he's a lay witness.
For your client, in opposition to your client, you're saying he's going to put in...
No, he's going to...
Should I clear up this right now with Mr. Parker, I think was taking this one? Mr. Parker, is Mr. Jones going to offer a causation opinion as to any of the... It has to be Brody, because that's the only one that causation does not currently exist?
Your Honor, that's a great question. And I will tell you, based upon the deposition of Mr. Jones, he will not get up and say that the consumption of Real Water caused Mr. Hunwardsen to get acute liver failure.
Or Miss Brody?
Or Miss Brody. I don't think
You've
either name is
you've got to carve out in
that
Brody's.
deposition.
Okay.
So, again, Your Honor, I think your question was is well pointed. It does not allow the defense to get around Rule 32, and it doesn't. In fact, I think it makes very clear that his causation point is not well taken, Your Honor, because it does not mention Hunwardsen or Brody in that deposition.
So, counsel, like I said, I just wanted to, if they were saying it, then yes, I'll hear the response. But I have to make sure, as you can appreciate, you all are the masters of complaint and defenses. Mm-hmm. And then you have to
Yeah,
Let the
my
court
point is,
go.
Jones is going to testify as to his opinions about what caused his injuries, which does not fall under the purview of testimony that should be set forth in his capacity as managing speaking agent.
Okay.
So if they're trying to introduce Jones's testimony as managing speaking agent, but they're going to set forth testimony like they did in Gallagher, where it talks about inadmissible hearsay, that should be excluded. It's a backdoor way for them to allow for him to testify. Well, I think that's what my doctor told me. I don't know. He said he felt like he got food poisoning in the morning. That's all very prejudicial to Terrible Herbst, and that's unfairly prejudicial.
Your Honor, just for the record, counsel is still, I think, maligning the decisions made by Judge Williams. You've already admonished him that he should not. I'm not saying he's intentionally doing it, but that's the result of the remarks he's making.
I've heard the objection. I've already given the caution to everyone. This is whose case this is. Who are your plaintiffs? What's the case at issue in this court? And my rulings are as to this case. Remember, it's also not to any other cases that are before this department, okay?
Understood, Your Honor, and I never mentioned any.
I'm not saying whether you did or didn't.
Yeah.
I've given everyone that friendly reminder. Okay. So
But
your
there is-
Rule 32 analysis is what with regards to what you're seeking to preclude. Because once again, and I appreciate lawyers who, shall we say, have some fluidity in their arguments by the time they come for oral argument before the court. So nuts and bolts. What are you actually asking to exclude on Blaine Jones that you want the court to do today versus wait to see with regards to deposition testimony as to what might be the actual testimony?
Right. Exclude reference and testimony related to Blaine Jones' alleged injuries.
Can I
Now,
have something a little bit more specific than that? That's why I said concrete. You want the court to exclude A, B, C, D. What's the A, B, C, D?
Any testimony that will be played by deposition from Blaine Jones as to his alleged injuries.
Go ahead, please.
Your Honor, the request is simple. Maybe I may not be coming across as clearly as I could on this front, but essentially what was played and a lot of the deposition testimony goes to what Jones believed caused his injuries, which is lay witness testimony, okay? And it's unreliable. As mentioned by himself, he's not sure, and it's inadmissible hearsay. So on that front, we would ask that any testimony by Blaine Jones related to his injuries be excluded.
Okay, appreciate it. Thank you very much. Here's the court's ruling. Based on the current understanding that Mr. Blaine Jones is going to be submitted, at least current view, subject to being changed at trial, with regards to deposition designations, whether that be video deposition or plain deposition, the court's going to find it more appropriate to rule on the actual testimony that sought to be admitted after each party's had an opportunity to do their counter designations and their objections thereto, and address this in one complete piece, rather than doing it piecemeal by trying to respond to a more global concept of any alleged injuries, which really can be too broad, possibly too narrow, since it's not clearly articulated what it is. The court can't just say because he said X in another case, that means by definition he's going to say that same X in this case. It might be the case, but I actually have to see what the potential X is with regards to the proposed testimony in order to evaluate whether or not it should be excluded or not. So I'm deferring motion limine number 14 to the date in which the 27th, I believe, is the date that we have set, to hear objections to deposition designations. And since I understand Mr. Jones will be included in that, of course, we're going to defer ruling on motion limine number 14 until that date, and remind the party to please bring that to the court's attention to the extent that you need the court to, I will have to address this in two separate areas, right? One under a motion limine standard, and two under an objection to deposition designation standards. And there may be some large overlap, but there may be some distinction, and if so, you all just need to bring that to the court's attention on the 27th so that you ensure that this gets fully taken care of that date. It is so ordered. Okay. So now, these are the ones for today. Now there's a couple of housekeeping things that came up with phone calls from various people on phone. There's a question I have to ask y'all. It's video exhibits, video whatever. But here's the question from this court. Do you all want to, and if you'd rather not, it's perfectly fine. We can wait till Monday. But realistically, some of the next ones coming out is similar to ones that may overlap with prior rulings of the court. So if there are any additional ones you wish me to address today, and all parties in agreement, then the court's prepped and ready to go. If they're not, and you'd like to be concluding with these, then that is going to be fine, and I will just address the administrative matter, make sure we're clear on whether or not you were talking video depths or video exhibits with a question that came to the clerk. Counsel for Terrible Herbst.
Yes, thank you, Your Honor. I think the court, if, with everyone's permission, can rule on Terrible Herbst motion eliminate number 17, document number 684, which is the motion eliminate to exclude Pham's testimony regarding his alleged injuries. I think Your Honor has already ruled on that.
That might be the one I was referring to since it was the next one up, but okay. Counsel for
Judge, I have no
the...
objection to,
Sorry, no objection?
no objection to hearing it. It's not really Pham's alleged injuries, it's his neighbor's injuries.
Okay. Counsel for Real Water, what do you want to do? I'm not trying to put anyone on the spot. If you all want it, I'll do it. If
Yeah,
anybody thinks they want to wait till
We're
Monday,
prepared
that's
to go
Monday.
forward on the next two and think that we've taken care of most of the next two, and they could go really quickly. Both Doc 687, ETT MIL 17, and Doc 612, Real Water MIL 4. I've heard the court's rulings. I think Real Water MIL 4 will be very short.
Okay. Well, since I have agreement at least on the first one, we'll get to the next one after that, and I'll ask you one by one, okay?
Four is fine with me too, Robert.
Pardon?
It's fine with me to argue for today.
Okay. Terrible Herbst?
Yes, that's fine, Your Honor.
Okay. Since one's yours, go ahead. Next one is document 684, Terrible Herbst motion eliminate 17 to exclude Pang Pham's testimony regarding his neighbor's alleged injury and consumption of real water purchased from Whole Foods. Go ahead, please.
Your Honor, I suggested this be heard today because I thought Your Honor already ruled on this in relation to the, let me just find it. Motion and eliminate number 10. When Your Honor indicated that Mr. Pham's testimony concerning his neighbors and why the ambulance was there and why they went to the hospital was excluded as speculative, but it's also lay witness testimony. There's no foundation for that type of testimony. And with that, I'll defer the rest of my time to respond to any additional comments that they may have.
Counsel for Real Water.
Nothing to add, Your Honor.
Thank you so much. Counsel for Plaintiffs. Go ahead, please.
Judge, I agree that we shouldn't be allowed to offer testimony from him as to what the cause was in that particular case. Personal observations, that he saw the real water on the counter, that he saw the ambulance trips. I think that is admissible. We can argue that we need to tie it up. Mr. Pham was pretty ambiguous about the dates he saw all these things. Some of them may have happened during the time frame he was with Real Water. Mr. Odou's providing further information to us that he knows the firing date now, which we didn't have at the time of the deposition or during the Gallagher trial. So I don't know that this didn't actually happen at the time he was employed, which would be a completely different thing. So with regards to the deposition, I think any testimony there that there was a causation connection that Mr. Pham gave, the court can probably exclude, but with regards to the observations, I think that's going a little too far because there may be a way to connect to the trial.
What would be the relevancy? That's part of the objection and the conclusion.
The relevance would be that we think this happened in May or June of 2019, and the Hunwardsen, and these are retail bottles, from Whole Foods. And the Hunwardsen case is 3 months later with retail bottles. That's the relevancy, that it's not as close in time as Haley and Gallagher, but it's not that far either. It's 3 months, Your Honor.
Appreciate it. Councilor Water, you said you didn't have any position, correct?
Your Honor, Mr. Pham appeared for trial last time to appear and testify in person. He just appeared on a date that we were not ready for him, and so he testified via video. We don't know which way it's going to happen this time. I just felt that was important information for everybody to have. And he showed up, and I saw him and greeted him, but did not talk to him about the case other than, are you here for the Gallagher case? Because I was not sure he was Mr. Pham, and he said yes. So we don't know one way or the other, but I understand they're going to do designations, and we can address that. I think their argument about he saw the water, he saw them go to a hospital, 1 + 1 = 2, is speculation and should not be allowed. Doesn't equal 2. We don't know why they went to the hospital, other than his conclusion.
Okay. Governor Herbst, you get last word. Go ahead, please.
Thank you, Your Honor. I think even the observations should be excluded for the very reason that it is speculation. They want to make the leap that because Mr. Pham saw some water, real water, on his neighbor's counter and saw an ambulance take them away, and therefore they must have suffered a liver injury due to real water. And there's absolutely no foundation for that. It's complete speculation. If he heard it from his own neighbors, it's hearsay. And for those reasons, I think the court should stick with its initial ruling and exclude his testimony as being speculative. It's a pure guess on his part. And to even allow him to set up those facts, totally irrelevant, without looping that in, without some testimony that was a result, those trips to the hospital were a result of real water. Thank you.
Thank you. Here's what the court's going to grant. Document 684, Terrible Herbst, limine 17, to exclude Tam Phang's testimony regarding his neighbor's alleged injuries, consumption of real water purchased from Whole Foods, in addition to what the court already said with regards to the ambulance. And here's really the reason why. Discovery is closed. You all had a full opportunity to depose him if you chose to depose him, to get the dates. Realistically, the court, I appreciate it wasn't even indicated what dates these happened. Would those dates have any relevance? The fact that he saw bottles, well, may or may not mean that they actually were consumed or not. I don't have anything that says whether they were full bottles, partially open bottles, whether they ever got, thrown away, actually consumed, who consumed them, if anyone, and anything that happened. So realistically, you do have speculation. You can't opine because he's a lay witness as to what would have happened based on what has been presented through. I'm calling it an offer proof because it's the best so far of what actually he testified to previously, even in the Gallagher trial, taking that aspect as being that would be some offer proof that he would be able to give some type of testimony in this area. The court wouldn't find what's been presented to this court as what he could testify to would meet the standards applicable to allow him to give such testimony. So the court does need to grant motion limine number 17 with the narrow phrasing that it's phrasing. The court's not taking a position because it's not before me with regards to anything he may testify at his job duties at real water, etc. I'm focusing purely with regards to the neighbor. It is so ordered. Moving on to document 612, real water's motion limine number 4 to preclude any testimony regarding a reference to the Gallagher trial and award. Court's inclination with regards thereto is with regards to the award. I think it's been clear made to this court. No one's going to ask it, so it's not even right, counsel.
Judge, I don't think we posed that. The reason we would pose it if it's broad, but we don't intend to talk about the Gallagher trial.
Okay.
We're going to caution all the witnesses not to talk about the fact that we've even been here before. So we don't really oppose this motion.
Okay, I thought you had some opposition with regards to some concept that it may come in with regards to
Yes, Your Honor.
yes,
It was
I know you all did. I'm sorry, it takes me a second. Go ahead, please.
the Haley and
That's
Gallagher
what it was.
facts. We just wanted to make sure that by agreeing, we're not going to talk about another lawsuit or a trial or a verdict or an award.
It
We're
doesn't.
not agreeing to exclude evidence related to Haley and Gallagher, who we've argued and believe is common exposure, a significant common exposure evidence and relevant in this case.
Okay. That clarification, counsel for real water.
Yeah, exactly, Your Honor. That's the clarification. They called us the Trojan horse, MIL. It really isn't. We're trying to exclude the Gallagher trial and the Gallagher award. They've already agreed that they will not talk about those things. We have separate arguments today even that we've made about excluding Haley and Orion Gallagher and Camille Gallagher. Those are the subject of other motions. They weren't the target of this motion. We all heard the ice cream truck when we saw the reply. We got into the argument. We got off on a tangent. Apologize for that, Your Honor. But no, this motion's very narrow, and I understand the plaintiffs have already agreed to it during the course of the day. So I think it's either granted or granted because of stipulation, or moot because of stipulation. There's two different ways we could do it. I hear them saying they're not going to do it. I accept that representation.
I don't mind you granting it.
Yeah.
Okay. So we granted it with the caveat that nothing in the court's ruling impacts the other arguments and issues still ripe for determination with regards to whether
Witnesses.
the witnesses could come in some context or documents relating to those witnesses.
Yes, Your Honor.
Does that meet your needs?
Yes, it does.
That meet your needs, counsel for plaintiff?
Yes, Your Honor. I'd also comment that Mr. Marlowe, especially, I think we're going to have a real serious discussion with him about this point.
Yes, we do. Mr. Marlowe is a different challenge.
He's a
for a
loose
different
cannon, Your Honor. He's
Well, he can have my trial management conversation if you like before he starts or he testifies.
you can tell him, Your Honor.
I said sometimes people ask me to do a trial management discussion with witnesses before they testify.
Mr. Marlowe's the one I would worry about the most.
I agree.
Inadvertently violating this.
No worries. Okay, so that meets your needs. Counsel for Terrible Herbst, do you want to jump in and give a position here?
I would join and have no other position, Your Honor. Thank you.
Okay, by agreeing the parties, this is granted consistent therewith is that there's not going to be any reference with regards to the Gallagher trial or award with this ruling not impacting, as court noted, other arguments with regards to some of the witnesses and or plaintiffs and how they may or may not come in other contexts or documents related specifically thereto. It is so ordered. That takes care of document 612.
Your Honor, what was I apologize, Your Honor. The last motion's document 684, that was MIL 17 or 18?
That was Terrible Herbst motion eliminate 17.
Okay.
I'm reading from the December 1 letter, so if it really has a different number, somebody needs to tell me. I'm
I just
basing
wanted
it
to
off
make
of.
sure.
Pardon?
Mine.
Okay. So,
39.
pardon?
It's item 39 on the December 12th letter.
You. Yeah. Okay. So the next one the court sees, and presumably you want me to wait till Monday unless you want me to do it today. It's up to you all. Like I said, is the next one was testimony regarding real water marketed and sold by Terrible Herbst after December 2019. Do you all want to wait that one until Monday since it's got some overlapping complications?
Yeah, we haven't really looked at it.
No worries, that's
I
fine.
mean, I'm familiar with it, but I haven't looked at it in the last
No.
48 hours.
No worries, we just had a little bit of extra time and trying to see if you all wanted more things taken care of. Okay, so let's walk through what we're going through on Monday then. Monday. Document 683, which is Terrible Herbst motion eliminate 21. Document 670, which is Terrible Herbst motion eliminate number 13. Document 659, which is Terrible Herbst motion eliminate number 3. Document 649, which is Plaintiff's motion eliminate number 15, and I'm going to ask you when we get to that one versus court some prior rulings on that one.
Oh, Your Honor, I believe we already handled number 15, document 649.
I thought we had, which is why I was double, okay. I've got a question mark, okay. Do all parties agree that the court already addressed document 649, plaintiff's motion eliminate number 15? I need to go back to, I thought we did on 1213. Let me go back.
We showed it was heard the first day, Your Honor.
Yeah, 1213, that's what, I'm,
649.
yeah, I heard it granted in part and denied in part. It was the 17th matter heard. right? So we don't need to, that one's already taken care of. Just don't have it. So I'm cross-referencing a couple of different documents here. Okay. So that the fourth one would be document 655, which is plaintiff's motion eliminate number 16, to preclude defendants from arguing and inferring violations of law, regulations are relevant to the compensatory or punitive liability. Yeah.
Correct, Your Honor.
Right. Okay. Next one would be document 669, Terrible Herbst motion eliminate number 6, to exclude Dr. Hutt's liability opinions regarding retailers and distributors other than Terrible Herbst. Document number 61 would be document 633, Terrible Herbst motion eliminate 25, to preclude plaintiff's experts Catherine Hutt from offering any opinions or testimonies concerning Terrible Herbst. So the first one is anybody else other than Terrible Herbst. The next one is Terrible Herbst. And then seventh would be document 609, Real Waters motion eliminate 1, to preclude the admissibility of the consent decree.
Your Honor, there's no opposition to that one. We could grant for non-opposition.
No opposition as well from Terrible Herbst. You concur?
I concur, Your Honor.
Okay, so you all wish me to advance to today document 609, Real Waters motion eliminate number 1, to preclude the admissibility of consent decree as being agreed to by the parties. Is that correct, Real Water? Would you like to be?
Yes, Your Honor.
It's your motion, so okay, I ask you to. Terrible Herbst, does that meet your needs?
Yes, it does, Your Honor.
Counsel for plaintiffs, does that meet your needs?
Yes, Your Honor.
That's, are you okay with that one? You got that one? Okay. Okay. Agreed. Okay, so then the seventh one would be document 473. It would only be limited to Terrible Herbst because this was a joint motion between Terrible Herbst and Costco, but it should be Terrible Herbst motion eliminate number 1, to exclude evidence in reference to STIP admission of liability of the Real Water defendants. And the one that you saw, and I'm sure there's going to be a notice of entry of order by Monday. So then we go to number 8, document 662, which would be plaintiff's motion eliminate number 17, with reference to plaintiffs Myles, Hunwardsen, and Miriam Brody's settlement with certain defendants. Is that even opposed, counsels?
I'm sorry, Your Honor, what was it?
Sure.
662.
662, which was plaintiff's motion eliminate number 17, to preclude reference to plaintiffs Myles, Hunwardsen, and Miriam Brody's settlement with certain defendants. I didn't see that that was opposed, but
I don't think we opposed that, Your Honor. I believe we agreed to do that even during.
in Real Water, I didn't see an opposition from you either. Is that correct?
Your Honor, we joined.
That's okay. Yeah. Like I said, I saw it as a non-issue, but I'm just making sure. So would you all like document 662, plaintiff's motion eliminate number 17, to preclude reference to plaintiffs Myles, Hunwardsen, and Miriam Brody's settlement with certain defendants be advanced today and granted as unopposed?
Yes, Your Honor.
Yes, Your Honor.
Your Honor, if I could add the caveat, this motion was filed before the subsequent settlements between all the Hunwardsen plaintiffs and the meter defendants. So, subject to there being no opposition, we'd like this order to encompass those settlements so that they're not referred to as well.
Okay. That makes you need. I think what you're saying, counsel, you're saying because the Milwaukee and Hannah Instruments resolution occurred after the filing of this motion, and that included more than just Hunwardsen and Brody, that you're asking that any of the settlements of any of the Hunwardsen plaintiffs not be referenced during this litigation. Is that correct?
Yes, that is correct, Your Honor.
Okay.
Real Water agrees and will not be offering any type of commentary or evidence about other settlements of other parties, period, whether it's the ones that we just mentioned or the ones that were in the motion.
The same for Terrible Herbst, Your Honor.
Okay, so would you like to advance EDCR 2.23 and granted EDCR 2.20 in its expanded form, which was a stipulation of the parties under EDCR 7.50 here in open court?
On behalf of the plaintiffs, yes, Your Honor.
Agreed for Real Water.
And agreed for Terrible Herbst.
Okay, you got that? Perfect. Thank you so very much. So that's 6. So then number 8 would be document 680. Terrible Herbst motion immediately number 8 to exclude the references to the Russians. That's still really an issue. You want that addressed on Monday as number 8?
We would, Your Honor, unless.
Okay. Counsel for plaintiff, are you going to refer to the Russians?
Well, Judge, there's no way Mr. Marlowe can testify without talking about the Russians.
I think there's a statement that I'm staying tuned for Monday to hear a little bit more of an explanation on.
We're laughing because we don't
No one's
disagree.
disagreeing, Your Honor.
Well, here's the question. Remember, this is whether counsel stipulate on behalf of their clients, not whether or not there might be a witness that may or may not listen to counsel's. If the court needs to know, do I need to make a ruling on it? Is it a ripe issue for determination by the court? And I do appreciate the humor, the camaraderie, everything like that, but is it a ripe issue for the court, or is it just a
Yes.
case management that you want me to say
Right,
something?
Your Honor, because, I mean, I think it's really kind of, well, I don't want to make my argument, but I think we probably should get a ruling on it.
Okay. We've got people want a ruling, we'll give you a ruling. Okay, so that's Monday, number 8. Document 647, Terrible Herbst motion eliminating number 9 to exclude arguments Ray rocket fuel. We'll just say that's going on for Monday. Okay.
Which docket number was that again?
Sorry, document 647,
647. Thank you.
which is Terrible Herbst motion eliminating number 9 to exclude arguments Ray rocket fuel. Then we go to the next one, which would be the 10th one, document 614, Real Waters motion eliminating number 6 to preclude plaintiff for referring to hydrazine as rocket fuel. So you might be asking me on Monday to hear Terrible Herbst and Real Waters motions in a combined fashion, but I will stay tuned to hear if that request is made on Monday. If there's a okay. Then we go to number 11, which would be document 668, which is Terrible Herbst motion eliminating number 5 to exclude the criminal history of Real Water employees. And then document 679, Terrible Herbst motion eliminating number 7 to exclude Real Water's interactions with OSHA, subject to what's already been discussed today. Then we go to document 682, which is Terrible Herbst motion eliminating number 18 to exclude references to Casey Aiken working at a strip club. And counsels, is that really at issue for the court anymore? I mean, I do appreciate that actually in your conclusion of your reply in motion eliminating number 20, you mentioned it again about the strip club, but I figured that was just a little oops. But is the strip club still out there, folks?
You know, Judge, at one point they say Mr. Akins is the most qualified technician in the world, and the other point they say he doesn't know what he's doing.
So you'd like the strip club?
No,
I'll keep it on
I
strip.
really don't want strip club. I can live without strip club, Your Honor.
Okay. Court's fine. These are motions that are filed. If the parties feel that there's issues for the court to resolve, the court's more than glad to resolve those issues. Is there a ripe issue for the court's resolution with regards to Terrible Herbst motion eliminating number 18 that needs to be resolved on Monday?
Yes, Your Honor.
Okay, so we'll keep it on that. It's number 13. And I think we can get to document 637, which is plaintiff's motion eliminating 9 to pre-admit the standard of life expectancy table, which is number 14. And here's the court's question. Are those is there only 3 other ones other than the deferral of the motion for summary judgment number 1 that's still left?
Yes, Your Honor.
Your Honor, may I just have a second? The question was there only
Sure.
3 left?
Okay. I have the 14th one being document 637, plaintiff's motion eliminating number 9. And I use as a reference point the December 1st letter and the subsequent stipulation that was filed by Hannah, and then the subsequent stipulations by United Natural Foods and Real Water of Tennessee. It appeared to this court that other than the one that was deferred because of the supplemental briefing, right, and I'm about to get to your motion to strike issue and your supplemental request for number 7. I'm not there yet, but I'm talking about the ones that are actually on this document. There were 3 additional ones. 688, which is plaintiff's motion eliminating number 30 to pre-admit the video of Myles Hunwardsen in the hospital. 657, plaintiff's motion eliminating 27 to preclude references to Hunwardsen marijuana consumption, subject to the court's prior ruling, but okay. And document 619, Real Waters motion eliminating number 11 to preclude plaintiff Hunwardsen future lost earnings. I'm just trying to get the global landscape of what's left because I'm trying to decide if I should stop at 14 for Monday or whether we should just go to 17, see if we really get there, but that way you all are prepped up, ready for those, and you might then decide to ask me to move Tuesdays to Wednesdays so that you have a day off although you probably want to see me every day on this case, but just in case you have other things you might want to be doing, I'm trying to make sure we use effectively everyone's time.
Those are all the motions, Your Honor.
I found one other one that was deferred. I don't know if I'm mistaken.
Is it motion for summary judgment number 1, which you're doing the supplemental briefing on?
There's additional one in there.
The motion to strike,
It was, nope, one more.
the
I have-
request, the OST that I have to talk to you all about, the
No,
OST
one
for
other
the supplement regarding Randolph?
One of the videos, number 7, I believe. You still have the first portion of number 7.
And I still
The two
have-
videos,
Right.
Terrible Herbst, the 2010 to
Right.
2019, 2 videos which you want tied to your OST request, which I have to talk to separately in just a moment. Okay, Mr. Parker, you're talking about something different. Go ahead,
Yeah, I
please.
still have plaintiff's motion limiting number 11 was deferred, based on my notes.
That was today. Mr. Parker, remember that was the first one we heard today. That's the strict product liability instructions.
I was thinking about something else, obviously.
No worries. There's a lot here. There's a lot of moving parts and a lot of changes, like I said, which is why I'm trying to do it. Okay, so then what it seems to make the most sense.
Your Honor, if I may,
Yeah, I didn't know
um, Terrible Herbst is going to withdraw docket number 670. That's motion eliminating number 13. Just real, 1 second now.
670? Okay, that was the second one up for Monday.
Okay, so that's motion eliminating number 13, docket number 670.
Hold on just one moment. Okay. The document 670, Terrible Herbst motion eliminating number 13 to preclude plaintiff's expert from providing speculative opinions on hydrazine degradation.
Yes, we're withdrawing that.
That's being withdrawn. Okay. There was not a substantive joinder by Real Waters, this court's recollection. Is that correct? Real Water?
We had joined, but we have no objection to them withdrawing now.
Okay. Okay. So, any others being withdrawn before I give my?
So maybe we
Counsel
can.
for counsel for clarity, I'm not going to go back over and change my numbering to the order sequence. You already have the order sequence, right? And you already have the document numbers. I don't think you want me to go back and repeat 16 different numbers, do you? Because everyone's got the order, you've got the document number, you've got the motion, correct?
Yes, Your Honor.
Correct. So everyone's good there? Is there any other withdrawn ones? Feel free to withdraw any others if you wish to.
No, Your Honor.
Nope, nope, and nope. Okay. So, what we've done is then to the balance of what's on this letter, there's, like I said, a couple of outstanding point ones that the court still needs to, let's take care of how we're going to do those. So, let's go, which one's up on Tuesday? Okay, so here becomes the question for you all. Okay, so what the court has not specifically addressed, well, we show for Tuesday the motion to strike. We show for Wednesday, we show the motion, plaintiff's motion for partial summary judgment number 1 that was deferred because of the supplemental briefing. We have the partial on the 2 videos, 2010 to 2019. Portion on plaintiff's number 7, and then we have a request by plaintiff to do a supplement relating to the so far deferred part of number 7. Is that, let's just get it clear, is that the outstanding issues?
And the supplement would also go to the motion to strike, Your Honor.
Okay. So, that's the motion to strike. Does anyone think that there's anything else outstanding?
Not from Real Water, Your Honor.
Not from Terrible Herbst, Your Honor.
None for plaintiffs, Your Honor.
Okay, and I'm not yet to depot, so, okay, so. With regards, it seems to me to make more sense that the court, in reviewing the order shortening time to file some type of supplement relating to the Randolph deposition, not taking a position yet on any of the procedural issues that anyone may wish to raise on it, but it seems to me it needs to be heard. Completeness makes more sense than lack of completeness. So, what it appears to this court is it would make sense to give a briefing schedule for both plaintiffs and defendants, and maybe it's only one shot each, maybe it's not a reply, it's most likely not a reply, because in fairness, you all have brought this on a super quick time period and where we're at, okay? But they give the maximum amount of time for an opposition for defendants, and then this get heard on Wednesday, and they move the motion to strike to Wednesday, so therefore you all, unless there's something I'm not yet aware of that you want to be here on Tuesday, you might be doing a couple other things on Tuesday. I am fine hearing things on Tuesday and Wednesday, but for your own efficiency, in order to give maximum amount of time for I'm just going to call it the Randolph deposition issue for supplements. I think that's the quickest, easiest way to phrase it, because technically, since I've already ruled in part on 7, I can't call it a supplement. 7, we have to find a better way to phrase it, but we'll get there. So first off, do you all want to come in Tuesday and Wednesday, or move Tuesdays to Wednesday?
Move Tuesday to Wednesday, Your Honor.
Judge, I think the stuff you've laid out here is pretty quick. You know, the Rocket Fuel, Strip Club, the Wizard of Oz. It's pretty quick stuff.
That's Monday, yeah. I think Monday it's doable to get through those, realistically.
Yeah, I think we'll probably talk about 2 hours, maybe 2.5 there.
That's how much, yeah. Okay.
I have no problem moving it to Wednesday
No, excuse me. I think you might not be clear. I was going to keep the Monday 16 items. It was originally 17, but 16 items
Right.
on Monday. Tuesday, the only thing currently teed up for Tuesday, if we get through all of Monday's items, and the current only thing teed up for Wednesday is the plaintiff's motion for partial summary judgment number 1, which you all were doing supplemental briefing. The court was asking you all, would you like the motion to strike to be placed on Wednesday so that there was no hearings on Tuesday in this case? Now, of course, one counsel will already be here on another case if they haven't done a check, but in any event, for this case,
I just like seeing you on it.
I didn't say anything. It's the additional friendly reminder when I have, I'm just saying, okay? So I'm just saying, for this case, you would not have hearings on Tuesday in light of the fact you may have other things you need to do, either in this case or other cases. If you all want to be here part day Tuesday and part day Wednesday, I'm here. You're more than welcome to be here.
I'm fine on Wednesday, Your Honor. My one question would be, what happened to the rest of motion to eliminate number 7? Is that going to Wednesday too?
That's going to Wednesday too. Okay. But that one has its own nuance factor because you all wish to do a supplement to that portion. That's why it was, pardon? Addendum, supplement. However, first time it was a supplement, this time it's an addendum, but since I partially heard it, I was going to think that we need to find an appropriate way to phrase it, but it gives the other side an opportunity to respond, right? Because it's the due process aspect. So, that's why the court was saying that I am finding that there is good cause to hear, I'm just calling it the Randolph deposition issue, okay, on order shortening time and how it would apply potentially or not potentially, depending on how people want to argue it, but allow some supplemental briefing from both sides with regards to the motion to strike and the portion of plaintiff's motion in limine number 7, which relates to the 2 Terrible Herbst videos, okay? So, I have 2 ways to do this. One, it would make more sense to submit a new OST that really does the agreement, because I'm going to talk to defense counsel to see, because presumably you may want supplements from your end, right, on both of those motions, or one or both, depending on how you think they apply to you or don't apply to you, and get a date. So by putting it to Wednesday, I can give you the maximum amount of time. Well, I'm going to hear what you're going to ask me. My preference is going to be end of day Monday, but you might ask me no later than like 10 o'clock on Tuesday, but I need some time to review it. So, okay, but to give opposition time. So let me hear. First prong, I guess, on any OST, the court can either evaluate an OST on its own and evaluate that it can set it on shortened time, or 2, I can hold a hearing on an OST. I have you all here. Given the court's inclination, I'm inclined to grant the OST, but to pick the most favorable briefing schedule so that counsels for defendants have an opportunity to provide their own supplement if they wish, and to respond to the OST, which you all should have gotten service on. Usually, even when somebody submits a proposed order to the court in the app, did you all click the box to serve it too?
You're way
Do you know?
beyond me.
Sorry, that's a Mr. Pepperman question, I think.
It wasn't me. My understanding is that's what we typically do. Is so if I don't want to make a representation that
Let me
defense
ask them if
counsel
they,
has it. but-
did you all get the proposed OST?
We received 2 yesterday, Your
Okay.
Honor, so
So you have the body of the document, right?
2 documents, yes.
But it's the same
So is-
document with some linguistic changes to try and make it so that it was a new, or is it changed in substance?
Submitted to the court as soon as
But they emailed it, they did it.
if they put them in as something, but they don't necessarily put regular service.
Okay.
Submitted.
Oh,
The change was, we understood there was a concern that 7 had already been resolved, and so we added in that there was still a part of 7 outstanding.
okay,
And then we emphasized that it also went to the default, the motion to strike.
okay.
That was the only change.
So body-wise, you got 2 documents, you understand that there's a few word change, but you at least have the document, right? I just trying to see if I need to add a service component, right, to it.
No, we have it.
Okay. Councilor Ruhlwater, do you?
We have no objection to this. We don't really have a dog in this fight, and having a dark day on Tuesday so we can get our deposition objections resolved and meet and confer sounds great.
Okay.
Your
So,
Honor, is this going to be an evidentiary hearing on Wednesday? Meaning, do you want witnesses here in court?
no,
Okay.
I wasn't anticipating it, because really the format that it was coming to this court, right, is one, well, let's go through each of the motions. Motion to strike generally is not an evidentiary hearing, unless somebody specifically requested. I did not hear any requests under Young versus Johnny Ribeiro. So am I hearing any oral requests for that?
No, Your Honor.
Ruhlwater,
No, Your Honor.
plaintiffs?
Your Honor, just, we're not,
Evidentiary hearing.
let me say this just based on the case law. Young Ribeiro dealt with terminating sanctions, and you know it dealt with it eventually with the evidentiary hearing. The Bahina case, which Mr.
Bahina versus Goodyear,
Posenberg
yes.
was, exactly, Mr. Posenberg was involved in, his big gripe and argument to the Supreme Court was the defendants were entitled to an evidentiary hearing. We believe that there's going to be sufficient showing that the court can strike the answer. But defendant at that point could ask for an evidentiary hearing in accordance with the Supreme Court decisions.
Which is why I was asking today, because if somebody's asking for it, they might want to prep people for
Exactly.
next week rather than wait till the day of when you're this close to trial with having the holiday season. Like I said, court's going to be here, but I'm trying to give you all as much notice of things so you all can figure out your own schedules, right? For the best possible ways that you might be able to spend some times with your families, friends, or whoever you choose to spend time with. Otherwise, the doors are always open here in Department 31. We're glad to see you, but presumably you have some things other going on in your lives. So if counsel, either defense counsel is going to request an evidentiary hearing by asking that today, gives the opportunity and gives people an opportunity to get prepared for an evidentiary hearing. I'm not making an affirmative determination that A, one would be specifically required based on what's presented to the court, nor B, I'm saying one is not necessarily being, because guess what? The technical underlying motion, right, is not before me today,
That's
but
right.
realistically, it makes sense that if somebody's requesting an evidentiary hearing, I ask you all today so that everyone can prepare. If you want me to ask you next week and you have a shorter time to prepare, and then I have to set it right before, I have to set it the week between, the holidays and we add something else to it, I'll do that, but I was trying to give everyone the most amount of time.
Your Honor, we appreciate the question because, again, we believe that the evidence will support striking the answer. And if defendant ETT is waiving that right at this point based upon the court's inquiry, then we look forward to next week. But I do appreciate the question given the Bahina decision, Your Honor.
I wouldn't say that I'm waiving it, Your Honor. At this point, we're not requesting an evidentiary hearing.
Okay, so what the court's taking that is, it's not being requested at this point, and I will address if any future request comes before me, because the court does not give advisory opinions. I don't need to refer to, like I said, my very nice crystal ball from my extern that does not read the future, but is still a very nice concept that we decided to get that. So, that being said, then as present, the court is scheduling these as regular hearings because there's been no request from anyone after court inquiry about whether anybody wants an evidentiary hearing. What's the impact of that down the road? Stay tuned on what people are going to say and do. There's just no present request. So that means I now need to circle back to the brief for plaintiffs is going to be done I have, like I was starting to say, there's a couple of choices. It can be resubmitted. I can tinker with some of the language, or I can just say, as agreed to in scope in open court by the parties in the briefing schedule, might be the easiest, if that's accurate. If that's not accurate,
That'd be fine with us. And Judge, I would note for the record, we have not changed the addendum at any time.
Okay.
The addendum stayed constant since the moment it was submitted.
I appreciate it. So what I understand is there was just a few words linguistic so that procedurally it could get on. Is that really where it was?
In the motion, yes, sir.
So, counsels for Real Water and for Terrible Herbst. End of day Monday or 10 a.m. on Tuesday?
We'll defer to Terrible Herbst. We probably won't be following the brief.
If we can have until 10 a.m. on Tuesday, Your Honor.
I offered it, you can have it.
Thank you. I appreciate it.
But I do need a real courtesy copy, please.
Understood.
Otherwise, it will not be right.
Right.
What I have by 10 a.m. is both. Okay, thank you. Otherwise, I don't have anything to read. Okay, so.
Deadline too, Your Honor, these are joint submittals? Is that what I
Well-
understood?
Well,
When you're saying joint, you're saying plaintiff wants another bite?
No, I don't want another bite. I
Okay.
thought you were implying I needed to bite some.
No, I was inclined not to give you one because I was, no.
We're done biting, Your
We're
Honor.
done biting.
Okay, no worries. Apple seems to have enough. Okay. The court's inclination, unless I was hearing something different from plaintiffs, is you already had an opportunity to present what you wanted to present because of the short time period in which you're seeking this to be heard, while the court's finding good cause to hear it because of the pending trial, all the various aspects raised, and it really makes more sense. The Supreme Court has talked about addressing issues prior to trial and for trial rather than waiting for an appeal, etc. So realistically, I find all good cause to hear it, but I need to give defendants the maximum amount of time to file any response they wish, because that way it can be fully heard.
Thank you, Your Honor. I just misunderstood what.
Oh, no worries. So you're okay with not getting a reply?
No, I don't want another bite.
Okay. So 10 a.m. on Tuesday for any defendant who wishes to file something, please get us a courtesy copy, okay? I am going to take care of how I phrase that OST that's currently in the app to basically take care of how we have done this for purposes of today. So that will be put on Wednesday as well. We're doing, do I have any other matters on Wednesday? Do I have my CD one or did that go off? So I have a wonderful team working in the background as I'm working with you all. So I had a couple other matters on Wednesday. I'm trying to determine whether we're starting at 9 or 9:30 on Wednesday is really the simple question. No worries.
no, I don't have.
Okay, so that got vacant. Okay. One of my CD cases, we still were waiting for something, so obviously we must have gotten that taken care of. Okay, so 9 a.m. on Wednesday. Monday, I think we do need to start at 9 a.m. in light of what we're getting taken care of that day, right?
Yes, Your Honor.
Okay. So see you 9 a.m. on Monday, 9 a.m. on Wednesday. Now let me try and address, there was an issue that came up. Somebody called about a video exhibit and how that gets to be done, but it wasn't clear whether they were referencing a video exhibit or they were referencing a video deposition. And so what I told my wonderful clerk in JEA is that I would ask counsel in open court what really was the request so that we could address it, because if it's just a virus check on a video, so Mr. Pepperman, I think you might be the one who might be able to answer what you all are questioning to see if the court can give you an answer.
Yes, Your Honor. Not several, but a handful of exhibits are video exhibits. For example, the Terrible Herbst commercials are videos. I believe, and I haven't been communicating directly with the people at the vault, but my understanding was there was an issue with submitting video exhibits in electronic form. The way
Would they be submitted? I'm sorry. By definition, aren't they electronic? Okay, I'm hearing what you're saying. I think the distinction may be under the current electronic protocol, which is a protocol which can be modified by any court, not an official rule or whatever it is. Okay, is my understanding, if that's the issue, is that it's just a matter of how many jump drives we get, because videos do not get virus checked by the vault. So I think if it going to a video exhibit, then that has to come to the court rather than the vault clerk, is what I have been told. So for somehow I go back to that one. Okay. I'm fine jumping in that. So is that where we're at?
Yes, I believe that is the issue. So just to clarify, all the document exhibits will be submitted electronically to the vault, and the designated video exhibits will be submitted separately on thumb drives directly to the clerk.
They play it. We don't play it. So they have to have
Yeah.
their computer to play it, and then the ones that are admitted will come.
Separate exhibit, separate jump drives, right?
Yeah.
Separate thumb drive, okay. So we had this in one other case. For videos, because the virus check program, I have been informed, I have no independent knowledge, does not have the capabilities to virus check a video. That while the exhibits themselves can get virus checked, which is why when you give us the extra drives, we can plug them into our respective court computers. For video, since it does not have that capability, if you're going to play a video exhibit, subject to it meeting all the foundationals, no objections, all that kind of good stuff, right? That has to be played off your own computer or whatever electronic device you have or your wonderful support people have, okay? And then if it's admitted, then it doesn't matter if you give us the drives in advance, okay? And you don't, I'm sure I really need to keep everyone for this in case you're interested in another time period, but on it, so is then give us those drives. The underlying exhibits that physically get transferred from proposed drives to the golden drive for purposes of preservation. Videos are treated differently just because the programming for virus checks is different. Does that answer whatever questions or needs you had?
Yes, it does for the most part. Just one point of clarification for your clerk, if I may. In terms of providing copies, the thumb drives with each, the separate thumb drives with the different videos on them.
8 videos, 8 sets of thumb drives, and you need 2 or 3? You need 2, right? Do you need you need 1 or 2?
I just need one. If it's submitted, I just put a sticker on it and give it to the vault. We don't play it. I don't put it in.
In terms of identifying them, is there a preference on how we do that, or just a sticker identifying the exhibit number? And
Are you putting your videos at the end? It might be easiest if you put your videos at the end of your designation section.
they are. They have a separate, they're at the end, they have a separate exhibit number for each video.
Like
We can put
656, 657,
Exactly.
658. Yes, we need that because that's going to be admitted 657, 658 or not, right? Or denied over objection. And then that jump drive, if it doesn't, right, becomes part of the record as not being admitted. If it does, then it comes part of the record that is admitted and over anybody's objection or by stipulation or however that comes in. So yes, separate ones, but you need to make sure, which is a non-issue here because you each have tech people, right? But it's to remind people who don't have tech people that they need to have some resource that they can play the video off their own equipment so that it does not get plugged into a court hard drive because of the virus issues and not being able to be checked by the vault. Does that take care of where you are?
Yes, thank you very much, Your Honor.
Sure. Does anybody else have any questions that the court can try and answer in that area? Okay, otherwise you're fine. With the number of jump drives, it's not required, but oftentimes people will provide the court, just like you gave me with these motions, an extra jump drive of your exhibits so that I don't have to address the integrity of anybody else's. Okay. But once again, that's not required. I'm not asking you to spend the extra $12 or whatever it is for jump drive these days. But if you can, great. If you don't, okay, that's fine too. Any other questions? If not, I'm going to wish you a nice rest of your day, and it's even earlier than anticipated. Counsels for plaintiff, is there anything else the court can do to address any issues or concerns for you today?
Nothing really plaintiff, Your Honor.
Counsel
Thank
for
you so
defense.
No, Your Honor, not from our water, Joul Odou.
How about Terrible Herbst?
No, Your Honor.
Have a productive weekend. Feel free to resolve the case over the weekend if you
I'm
wish.
glad you're right.
Very much, Your Honor.
Okay. You are first up on Monday, so if anyone needs to leave things, same thing area over there.